In your filings, in not wanting to allow the victim to maintain her anonymity, you made the following argument in writing, quote, "A court must balance the plaintiff's interest in anonymity against both the public interest in disclosure and any prejudice to the defendant," close quote. I'm not aware of any precedent that supports this position. It does, moreover, appear to contradict every norm in any courtroom in America with regard to a child victim. I'm not aware of any courtroom in America where a child victim, whether still a minor at the time of the trial proceedings or not, where the victim wouldn't be allowed freely to choose to protect her anonymity. So I'm struggling with this. Can you please explain to me how it is that you think, or that you thought at the time? And normally I defer to nominees in the sense that when somebody has a client to represent, they make arguments. Those arguments don't necessarily reflect the attorney's personal views. But there are some circumstances where lines are crossed, and where an attorney goes beyond the duty and the professional obligation of providing zealous representation and steps into some really murky hinterlands, to put it charitably. Can you please explain to me where you got this formulation? Here you have to balance the interest of any prejudice to this ritzy elite boarding school against a child victim who was still a child at the time of the trial proceedings. Can you explain what balancing that is, where you get that, and how you thought that it was even a decent argument?
Thank you for the question, Senator. As an advocate, the school did agree to allow the family to proceed.
Well, how kind.
Anonymously.
It's not something that they bestow. Yeah. This was something that you were trying to stop, a right that she had that you were trying to foreclose.
And what we did in the case, Senator, is we provided Judge Barbadoro in New Hampshire with an order that had recently been issued by Judge Walton in the District of Columbia, where he had both allowed the sexual assault victim in the case to proceed anonymously, while he simultaneously placed restrictions on the lawyers from speaking about the case publicly. So we asked Judge Barbadoro to adopt a position that had recently been ordered by the federal district court in the District of Columbia. In addition, Senator, there has recently been—
That was not at the same time you were making this argument, that the victim's interests have to be balanced against the risk of prejudice to the institution, an institution that, according to the allegations, and as I understand the facts, an institution that was aware of this senior salute, aware of the fact that it had not just become a tradition of debauchery, but of child sexual predation. What interest is there to balance there?
Senator, the Proud family had just a very strong interest in proceeding anonymously. There's no question about that. The school was asking the court to restrict trying the case in the media while that anonymity was being respected by the court. I will note that if I were confirmed to be a judge, there is recent case law that has been adopted by the First Circuit on this very issue as recently as August of 2022 that sets forth a standard I would be obliged to follow regarding the use of anonymity in court.
Well, yeah, that's great, and I'm not worried about circuit precedent at this point. I'm worried about the argument that you saw fit to make, and I find the argument that you appear there to have been making against anonymity of a child sexual victim who was still a child at the time the trial was taking place, particularly confusing when in another high-profile case involving child sexual assault victims and the Boy Scouts of America, it doesn't appear that you ever objected to the use of pseudonyms to protect the privacy of plaintiffs who at the time had reached adulthood, unlike Chessie in this case. So how do you account for the different approach in the two cases, one involving a minor female plaintiff, still a child at the time the trial proceedings were taking place, and the other case in which there were several by then mature male victims?
Senator, I don't recall the specific case you're referring to involving the Boy Scouts of America. I would like to simply acknowledge your point that I agree that under existing precedent, it is perfectly appropriate and so necessary for survivors of sexual assault to have the opportunity to proceed in court anonymously.
Okay, my time's expired. I just want to ask one yes or no question, be very, very brief. So, do I understand you now to be denying that you tried to deny the victim her right to anonymity? Or are you saying you did not do that?
I am saying that the school assented to the family proceeding with anonymity
after you had made this argument,
provided that the judge imposed conditions against the lawyers trying the case in the media.
But that's not the argument you were making there. Thank you.